Good morning, everyone. I'll just wait a couple of minutes so that, or a couple of moments, just for everyone to let themselves in the room. I can see the numbers going up. So, morning to everyone who's joining. I'm Angie Crush and I'm a partner here at Thomas Mansfield. Today I'm joined by my colleagues Julie Goodway and Meredith Hurst.
Good morning.
Good morning.
Now, I know many of you have been on probably plenty of our webinars now, but for any newcomers, because it seems our figures do go up each time, I'll tell you a little bit about Thomas Mansfield again while we're waiting for people to join. So Thomas Mansfield, we're a specialist employment law firm. We work with a wide range of employers, from large employers with sort of entire HR departments. We work directly with HR managers and their teams as an extension of their business. And we also work with business owners who don't perhaps have a separate HR function. We also regularly work with HR consultants who from time to time still need backup on the trickier cases they might be dealing with for their own clients. Now, today's webinar focuses on what you might call the bread and butter of our daily work, settling workplace disputes. Now, we're going to look closely at pre-termination, including the statutory procedure and the without prejudice rule, behaviour, workplace mediation, dismissing senior executives, and also a look at settlement agreements themselves. So many of workplace disputes end up with a settlement agreement. Now, on your screen, you should see some buttons, including a chat box. Now, we think today's topic is one that's ripe for questions and interaction. So we'd really like you to ask whatever questions you have on the webinar today. Just pop them in the chat box and I'll get them answered at an appropriate time. There's also some other boxes, an offer box and a poll box, which we'll look at during the course of the webinar. We've also prepared a document which you'll see in the files section, which is a flow chart that sort of sets out a sort of Q&A, how to sort of guide your way through a particular workplace dispute that you might have, whether you can use a settlement agreement, etc. So please do download that document because it's there for you all to use going forward. It's a really handy document. Now, before we sort of get into the nitty-gritty of it, as I said, most sort of workplace disputes very often end up with settlement agreements. So just to get an idea of who out of all of you viewing use settlement agreements, if an employee exits the business, I've just published a poll just to ask how many people offer settlement agreements. Yes, always, although notice the typo in the word always, don't hold it against us. No, never. Or only if warranted, so you wouldn't generally use them, but you might use them from time to time. So looking at the results at the moment, there's no one that's never used a settlement agreement, and certainly that accords with our experience that, you know, most employers will have given settlement agreements out from time to time. But there's around 15% saying yes, always. And about 85% saying only if warranted. So looking at that, I'll end the poll there, but it certainly looks as though the majority of you use them when the circumstances mean that it's a good idea. So Julie, is an employer required to consider offering a settlement agreement when things get tough?
Well, it really is the employer's decision. It's the employer's choice as to whether they want to offer a settlement agreement or not. The only caveat, though, to that is if an contract refers to a settlement agreement being offered in certain circumstances. For example, enhanced redundancy pay being conditional on an employee entering into a settlement agreement. But that type of situation is rare, and we'd need to look at the specific wording of that policy or contract. Otherwise, the general answer is no, it really is the employer's choice.
So if there's no obligation, what might an employer want to consider offering a settlement and reaching a settlement deal with an employee or ex-employee?
The obvious scenario is where an employee has issued an employment tribunal claim, or it's believed that the employee is likely to issue such a claim. But there can be other scenarios as well where an employer may be looking to arrange an exit deal with an existing employee. Those type of obvious examples would be if you've got a disgruntled employee, somebody who's raised a grievance, maybe you're concerned about an employee's performance, it's below par, or there's a disciplinary allegation that you need to investigate. And the other example would be if you're about to start embarking on a redundancy consultation exercise. Now, of course, the employer could go through all the right processes with all of that, but it's likely to be very time consuming for the employer to do so. Also, the employer can follow absolutely the right procedure, but there's still no guarantee at the end of the day that the employee will not bring a claim. The only way of making sure that a line is drawn under this is to offer a settlement agreement and to conclude a settlement agreement, provided, of course, that it is all done correctly.
Angie, you're muted.
Sorry, it has some background noise, so I turned my audio off. Talking about doing it correctly, one tip I would sort of give to anyone, bearing in mind that you are using you're using settlement agreements from time to time, but perhaps not all the time, is to make sure that they are updated. I'm just going to publish a poll to ask, for those of you who are sort of using settlement agreements, when's the last time they were updated? Is it in the last months, 1 to 3 years, or more than 3 years? And the reason for that is I certainly still see a lot of settlement agreements come across my desk that perhaps refer to the 1998 Data Protection Act and no reference to the 2018 one. And so you instantly know that your opponent isn't up to date on things when you see sort of an old settlement agreement. So looking at the poll, it does look like the majority of people, 70%, have updated their agreements in the last 12 months. That's really good. For anyone who it might be more than 3 years, you probably definitely need to, 1 to 3 years, there have been some changes, sort of new legislation introduced. So I would just check, things like those references are up to date. Now, Julie, some employers may be concerned that offering a settlement sets a precedent for others. What's your view on this?
Well, and I certainly understand that concern, because many, if why an employer would have that concern. And the reason being is because if other employees become aware of settlement agreements being offered, it's likely to mean that they would start maybe bringing a grievance or making a claim with a view of getting some form of a financial deal. And of course, no employer will want that. So my advice in that situation is to, where you've got an existing employee and you're offering a settlement agreement, to make it clear at the outset to the employee that this must be kept confidential. And do that both in writing and verbally. Now, I act for both employers and employees. So I'm often advising an employee on their settlement agreement. And it always surprises me how many employees come to me not having been told beforehand that they need to keep the agreement confidential. Now, of course, in the settlement agreement, it's likely to be very specific. You're meant to keep it confidential. But most employees will not be reading that agreement and won't understand that need until they're taking advice from their solicitor. By that time, they may have told half of their team about it. So a key point to note here, do make sure that you tell the employee that it's confidential, explain to them that if they breach this, then it may well be regarded as a disciplinary matter, and also all deals will be off the table.
Good advice. So when thinking about issues to consider if you're going to offer a settlement agreement, Meredith, can you take us through some of those issues that employer will be thinking about?
Yeah, sure. I mean, I think the first thing is, has the relationship reached that point? Is settlement absolutely necessary? Normally when employer clients come to me, they've kind of made their mind up. There are various reasons why that might be. Performance issues, a conduct case, the employee not being the right fit, a breakdown between manager and the individual. That will usually inform the degree of risk and approach to be taken. The next obvious question for me is, how long has the individual worked for you, for your organisation? Do they have the requisite length of service to claim ordinary unfair dismissal? If they don't, and none of the protected characteristics apply, none of the automatic unfair dismissal reasons apply, they haven't alleged whistleblowing, asserted a statutory right or something like that, then you can afford to approach things fairly robustly. You might decide actually to dispense with the settlement agreement altogether. If the employee has fewer than 2 years employment and none of the exceptions apply, as I say, you may dispense with the idea. But if there is a potential risk of a discrimination allegation or a whistleblowing claim, then you may more readily consider early settlement in those cases because of the necessary length of litigation and the complexities involved.
And does it make any difference if the employee has raised a grievance, for example?
Well, it can in the short term, certainly. Often an individual will have raised a grievance having sought legal advice of their solicitor, or they might have a genuine gripe if the relationship has reached that position. Now, it can be used as a tactical ploy to force the employer's hand into offering settlement, as Julie mentioned. In the immediate term, that is a problem because it's something the employer's got to deal with in practical terms. But the employer can turn to their advantage by properly investigating the grievance, perhaps putting forward a low offer to settle before communicating the outcome. And that can put the individual into what I might call a fight or flight frame of mind, having to decide whether to, well, there are various options. They may go on sick leave, they may resign, or they may stay put and put in ACAS early conciliation procedure if they've got a discrimination claim with an upcoming limitation date. That could resolve things in the short term, of course, but it does necessarily complicate the situation, yes.
Okay. And before I ask my next question, there's a question come in, which is, can fixed term contract employees go for a settlement agreement as well, or only for the permanent employees? I mean, I think the answer to that is that they're for everyone. There's no reason that you can't use a settlement agreement for a fixed term employee. Indeed, they can be used for workers, because a casual worker may have some certain types of claim, or you may be heading off certain types of claim. So absolutely, they can be used with anyone. And sort of following on from that, does it matter who you're dealing with, Meredith? I mean, I'm not talking about the mafia or anyone here, but does it matter which type of employee you're dealing with here as to how an employer might approach things?
Well, I think certainly from a personality point of view, I mean, one thing I often discuss with my employer clients is, what's this person like? How realistic are they? What sort of personality type are they? Are they going to readily accept a settlement? Are they unrealistic, or are they anecdotally difficult as an individual? More importantly, is the individual, let's say, in a regulated position in the financial services sector? Are you going to have to go through a disciplinary process to satisfy the regulator? Because if you are, settlement may not actually be your first port of call there. It's usually broached, settlement is usually broached, I say, when you're looking at ending the employment more often than not. And you've got to think about making a settlement sufficiently attractive to ensure that the individual takes the bait, as it were. That can also depend upon who you're dealing with, how realistic they are, the level of their remuneration, and so on. And following on from that is, what does the contract entitle that person to? Aside from any financial incentive for waiving their employment claims, does the individual have a lengthy notice period? Do you want to try to negotiate that down? What else are they entitled to under their contract? Incentives, shares, that sort of thing. What arguments will the individual put forward? And I think you've got to be alive to that as well.
And are there any other issues that you'd consider, such as the timing of an offer, perhaps?
Well, I think timing is quite key often, and it can be important in disciplinary cases. It can be compelling to begin the disciplinary process, present the case, and offer a settlement before you communicate your decision, because in that way the individual has a stark choice, accept a settlement or possibly face a sanction. But it's very important that any discussions you have in that context about settlements are conducted on what we call a without prejudice basis, so that the employer doesn't prejudice a fair outcome in the disciplinary if the settlement discussions fall down. We can't stress enough, and I know Julie's mentioned that even if you do follow a fair process, people will still complain and bring claims, but it's very important that you follow your own procedures correctly. You don't want to give an individual ammunition to attack you with down the line when negotiating. You can assume that once you've broached the question of settlement, they will have rung a solicitor probably, and they'll be seeking legal advice. Following on from that, of course, if you get an inkling that somebody has got a lawyer, either because they've written to you, the lawyer's written to you, or they're writing in such a way that you think, hang on a minute, they normally can't write very well, but they're getting legally crafted emails sent to you, you need to think very carefully and scripting the conversations that you have with them, with the assistance of lawyers yourselves. And you should avoid any suggestion that dismissal is inevitable during those discussions, because again, if the settlement falls down, then that can be used and that can be quite uncomfortable. And it's in response to that that the government introduced what a lot of our listeners today will know about, which is the section 111A, protected pre-termination negotiation regime, which is a statutory regime. But it does have significant limitations and doesn't protect the employer from allegations of discrimination or from impropriety. And Julie, again, will talk to us about this. If offering a settlement which requires somebody to get legal advice, then you can pretty much guarantee that they will come back with questions, so be prepared for that. Finally, and importantly, if your organisation has the benefit of employment tribunal insurance, it can be important to notify the insurer early of the circumstances giving rise to potential settlement discussions or risk invalidating your insurance policy.
That's really important advice about the employee insurance at the end there. And yes, I think everyone can spot those ghost-written lawyers' letters a mile off. So, Julie, Meredith mentioned there that there are different ways to approach the conversation, either a without prejudice discussion or under Section 111A of the Employment Rights Act. What's the difference between these, and when should each of them be used?
Well, in general terms, a without prejudice conversation should only be had if there's an existing dispute, and the without prejudice conversation is a genuine attempt to try to settle that dispute. In contrast, a Section 111A discussion can take place without there needing to be any ongoing dispute. However, that type of discussion can only, well, the admissibility rules regarding it will only kick in if it applies to a pre-termination discussion. Now, that's quite a simplified approach to explaining it, and I believe that we're about to look at it in a bit more detail. And just to clarify, so as going forward, when I refer to a Section 111A discussion, it's a bit of a mouthful, so I'll probably just use the words protected discussion.
Okay. And it's definitely, I think, an area that crops up in negotiations where we get brought some conversation and it says without prejudice, but we say, well, that wasn't actually a without prejudice conversation. We're able to use that. And so it's definitely an area where I think there's perhaps a little bit of confusion, or sometimes there's not a full understanding. So can you explain what about the criteria for a without prejudice conversation? You mentioned that there's a need for an existing dispute and a genuine attempt to settle it. So go into a bit more detail on that criteria.
Okay, so absolutely, both of those criteria are needed to help to ensure that a without prejudice conversation will not be admissible in any tribunal proceedings. Now, often I find that employers and employees too will tend to use the words without prejudice in more or less all communications, and they do so thinking that this is going to give them some form of protection. But that can be a costly mistake, particularly if it is said in relation to communications that you wouldn't want to be made public or to be before an employment tribunal. So we've said that there are these two main criteria in terms of without prejudice communications. The first is about there needing to be an existing dispute. Now, clearly, if somebody has brought an employment tribunal claim, then that indicates that there is an ongoing dispute. A dispute can also be held to exist where an employee might reasonably be contemplating bringing a claim. But this thing about a dispute, it's a bit muddy in places. For example, what about a grievance? If someone has raised a grievance, does that amount to an existing dispute? Well, no, according to the Employment Appeal Tribunal, in the case of BNP Paribas against Mezzotero. And in that case, the employee had raised a grievance. And as I say, it was held that no, that does not amount to a dispute. And the reason being is because when an employee has raised a grievance, it may well be that it gets upheld, or it may be dismissed, but on grounds that are acceptable to the employee. The other thing is that there has to be that genuine attempt to to try to settle the dispute. And a good case here of when it was held that there wasn't a genuine attempt to settle an ongoing dispute is the case of Hudson against Oxford University. And here, Mr. Hudson had appealed against his dismissal. He was very clear that he wanted his job back. But when the Oxford University made a settlement offer to him, they made it very clear, you will not be getting your job back. And in that instance, it was held that that was not a genuine attempt to settle the dispute. So it really is important to be clear about the criteria for a without prejudice conversation.
Yeah. And are there occasions when, even when, for example, that criteria is satisfied, there is a dispute and there is an attempt to settle it, when even though those things are in place, a without prejudice conversation could still be admissible?
Or yes, there are, but these tend to be quite few and are quite narrowly construed. One example of that is the issue of unambiguous impropriety. An example of that is if a line manager purports to have a without prejudice conversation with an employee, and during that conversation they say, the reason we want you to leave is because you're black. Now, clearly, when that employee is then going to likely bring a race discrimination claim against the employer, if the employer tries to get that evidence not to be admissible, then the tribunal is going to have short shrift of that and say that it would amount to unambiguous impropriety.
Thank you. So yeah, it illustrates that we do in these situations have to work quite hard to make sure that we get the protection from without prejudice, and that it can never be guaranteed, but there are mechanisms we can use to try and get that protection. Now, turning to the protected conversations, or call them. You mentioned before that these are only applicable to pre-termination negotiations. Are there any other criteria for these conversations?
Well, yes, absolutely, you're right. So it does apply just to the pre-termination negotiations. It only also applies if an actual settlement offer is made. The other crucial point to note about protected conversations is that they're only not admissible in ordinary unfair dismissal claims. So if an employee is bringing another type of claim, maybe a discrimination claim, an automatic unfair dismissal claim, a whistleblowing detriment claim, for example, then that conversation would be admissible. Also, though, a protected conversation will only be inadmissible if it does not amount to improper behaviour. Now, what is meant by improper behaviour is not clearly defined in the legislation. But clearly the example that I gave before of unambiguous impropriety would amount to improper behaviour. Helpfully too, there's an ACAS code on settlement agreements, and that gives us some examples of what is meant by improper behaviour. These examples would include harassment, bullying, intimidation, so offensive words or aggressive behaviour. That's not acceptable. In the same way that discrimination because of a protected characteristic isn't acceptable. Also, if an employer puts undue pressure on an employee, examples of this include if an employer says to an employee, if you don't accept this offer, then we're going to dismiss you, and they do that before commencing any form of disciplinary process. Or if the employer does not give a reasonable opportunity, a reasonable time for the employee to consider the deal that is being made to them.
So you mentioned a reasonable sort of time to consider the offer, and the ACAS code refers to 10 calendar days. Now, that's sort of a fairly long period of time. Must an employer adhere to this 10 days?
I think here to remember is that the ACAS code is just guidance. Now, I would say that 10 days does seem like a long time. Clearly, the employer needs to be giving the employee a reasonable opportunity, a reasonable time to consider the offer. But 10 days, as I say, it does seem like a long time, particularly if the employer is allowing the employee to be on paid leave during that time. Also, not really much of an incentive for the employee to be coming back to the employer. So I would wonder whether 10 days, as I say, to me, it does seem too long. But of course, if you as the employer want to follow the ACAS code in relation to that, then absolutely you can do so.
I guess it's one of the factors that an employer will consider in deciding whether to go down the without prejudice route or the protected conversation route, because certainly with a without prejudice discussion, we probably wouldn't be giving them 10 days, we'd be giving them much shorter. But it's all that there are a lot of pros and cons, and just to sort of set a bit of background about why these protected conversations came in, I always found that because you sort of had to artificially sometimes set up this dispute to get without prejudice protection, you instantly sort of set the parties on polar opposites. And it was sort of to alleviate this artificial setting up of disputes that the government introduced the protected conversation. But there are definite pros and cons to each and reasons why you might want to try and go down one route rather than the other. Looking now more at the actual how to sort of conduct the settlement discussion, have you got any tips on what employers can do when having that discussion?
Well, yes, certainly. So at the start, do ensure that you seek the employee's consent to have a without prejudice conversation. Make it clear that to the employee, maybe use their language as well, say that it's off the record, use the words without prejudice as appropriate, use the words protected, conversation as well, but do obtain their permission to continue on that basis. Also, don't say anything that's going to come back to bite you. My advice is always to proceed on the basis that the conversation is likely to be admissible or that it may be being recorded. Also, when you do have the conversation, you'll want to give the individual an understanding of why you are offering the settlement. Maybe in general terms, explain that you've got some concerns about their performance, or that there's this allegation of misconduct against them. But don't give them the impression that you've already made your decision on this. So sometimes less can be more in terms of what you say. Consider also maybe the amount that you're going to be offering them and how you will explain this to them. If you're not going to be prepared to put forward any further offers to them, then explain that that is your top amount, so that at least they're aware of where the bars are. You may also want to consider whether there are other options that you can give them other than just a settlement sum. So other things that may be a sweetener to them. For example, maybe offering them a payment in lieu of notice rather than working their notice or being put on garden leave. Can you look at waiving some of the post-termination restrictions or looking at shortening them? And also maybe an agreed reference, although an agreed reference may not be something that can be offered in terms of it's not always something that can be offered in the financial sector. And the other key thing here is have a script for your meeting. Now, just to give an example of when things can really go wrong, when you don't have a script, or if the line manager perhaps goes off script. And here the example that I've got is when I was acting for an employee. That employee had raised before a sex discrimination claim. His employer obviously wasn't very happy about it. And out of the blue, his line manager calls him into a meeting, tells him it's going to be without prejudice, and then proceeds to tell him, we're not happy at the fact that you've brought a claim, leave, clear your locker out, and we'll offer you a settlement. Now, that was not the right thing to do. My client subsequently brings a victimisation claim because it appears that the reason that they're dismissing him is on the grounds that he has made a sex discrimination claim. Luckily for my client, but unluckily for the employer, my client had recorded that conversation. It then is decided by the tribunal as to whether that's admissible or not, and the tribunal holds that it is, primarily because my client had not agreed to the without prejudice communication. So, as I say, if you do have a script, and make sure the line manager follows it.
Okay. Is it ever appropriate to suspend the employee during settlement discussions? What happens when you're in the midst of these discussions? What do you do with the employee?
Well, suspension is something that you would use normally use when an employee you're concerned about misconduct by an employee, and you're concerned that during the investigation, the employee may hinder that or may cause damage to the business. I wouldn't say that suspension itself is ever appropriate just because you're offering somebody a settlement offer. In the same way, remember, don't use the words garden leave, that you're putting the employee on garden leave during any settlement paid leave. And the reason for that is because garden leave is the term that you'd use once notice has been given to end someone's employment. So unless you are ending someone's employment and you're prepared to say that, don't use the words garden leave. But of course, many employers will want an employee not to be around in the business while they're considering a settlement offer. So my advice here is to give the employee the option of taking paid leave while they consider it. And I expect that most employees would want to do so.
Yeah. And also you can then explain to the rest of the team, they're on a couple of days leave, so you're not ever prejudicing their ability to go back to work if the discussions don't pan out. Looking now at sort of settlement when legal proceedings are already underway, Meredith, are there different considerations that an employer would have in those circumstances? Well,
there are different and there are similar, but we'll look here at the ACAS early conciliation process. What we're really talking about here is when someone has started that process or when employment tribunal proceedings are already underway. Now, remember that ACAS early conciliation is now a requirement before a claimant can bring a claim, and that can take place during the employment. For example, if they've got a discrimination claim, they don't have to leave the employment to bring that claim, for example, and they've got a limitation deadline looming. Or it can be started once the employment has ended, obviously as a precursor to litigation at that stage. It's important to bear in mind when negotiating with an employee, bear in mind that ACAS early conciliation is often threatened in tandem with a grievance. They bang a grievance in. If we don't get what we want out of a settlement, we'll be going forward with ACAS early conciliation. Those two things normally go hand in my experience. Remember, though, that there's no obligation on you as an employer to engage in ACAS early conciliation, by the way. So some of my clients will say, we're not going to engage at the minute, we're going to test the claimant's mettle effectively in order to frustrate the claimant and delay possible settlement litigation. So if you believe you've got a good defence to threaten litigation and you don't want to send out the message that, we're a soft touch and we settle, then you'll take the view as to cost benefit at the early stage and perhaps decide not to engage. On the other hand, you may do, because you might get a shot at the claim early or a prospective claim early. So moving on to that, consider, does it make sense to settle early, or is it better to push back in those early stages and hope that the individual never brings legal proceedings? Because I've had experience of the ACAS early conciliation process goes in and you never hear anything. So indicating that you don't want to settle at the early stage can send a message, as I say, to the individual that they better think carefully before bringing legal proceedings. We're not the cash cow you think we are. On the other hand, we are seeing far more employment tribunal claims now, I think, progressing since the employment tribunal fees regime was abandoned. And you'll normally get a feel for the sort of individual you're dealing with and their appetite for litigation. Once proceedings are issued, it's very important to get an early merits assessment, so an early assessment of what you think your chances of successfully defending the case are. And thankfully, the standard directions in employment tribunal process require that a claimant must provide a properly quantified schedule of loss, and tribunal agendas, which are referred to at the preliminary hearings in largely discrimination claims, urge the parties to be realistic. Bear in mind that even with that direction, schedules can be completely unrealistic and include spurious claims for long future loss, and we've seen many with several years future loss. I received a schedule quite recently where the claimant, bear in mind they were represented by solicitors, had claimed for death in service 3 times. Sorry. So I wrote a letter to their lawyer to say, as far as I'm aware, your client is not dead, but very much alive. Please revise your schedule. And they came back, sort of tail between their legs, and said, oh, yes, we got that wrong. What they could have claimed for is the cost of life cover, possibly. That's maybe 20, 50 quid a month or something, but not the payout in the event of death. So schedules of loss can be misleading, and it's important, I think, and quite useful in some cases to prepare a counter schedule. Can also be useful, and indeed the burden is on the employer to demonstrate that the individual has failed to mitigate. Now, if they're, let's say, a bus driver, those kinds of jobs are readily available. The employee can't sit on their, or the ex-employee can't sit on their hands and do nothing. They'll be expected to make reasonable efforts to mitigate and find alternative employment. And it's sensible to make inquiries of the individual. What are you doing to find alternative work throughout the litigation?
Yeah, it's always good to send them, some copies of job adverts that you've seen and say, can you confirm you've applied for all of these? And if they haven't, then they haven't mitigated and the tribunal will take all of that into account. Are there points during the life of a tribunal claim when it might be more beneficial to consider settlement?
Well, I think so. Looking at it commercially, purely commercially, and I'm a big fan of looking at things commercially. Not all organisations want to do this; they don't want to send out the wrong message. But there are points during the litigation when you think actually we can get rid of this claim rather than spending money on defending it. Pre-ET3, that's once the initial claim has landed. I find that once a claim has landed, you're less likely to achieve settlement, I think, because the individual's gone to the trouble of instructing solicitors, spending money on getting the claim issued. They aren't likely to necessarily capitulate at that stage, but you might consider it. But I think more powerful at that stage is for the employer to lodge or file with the tribunal a very robust response to the claim, and it can encourage the claimant to be realistic. Pre-disclosure, disclosure can be burdensome. It's painful exercise in a particularly document-heavy case, and I don't think you necessarily see settlement at that stage. But it would avoid having to disclose evidence that you're particularly worried about that damages your case. On the other hand, if you have powerful evidence which damages the claimant's case, then it's undoubtedly better to disclose it and then perhaps offer a low settlement at that stage if you want to. Pre-witness statements. I've often had respondent lawyers contact us to say, our client has a pot of money set aside for witness statement preparation. We can allocate some of that to settlement, but once we start the work on witness statements, that pot is going to dwindle. And I've used that myself, and it has been successful. But it may well only suit relatively low value claims in my experience. Ultimately, this all comes down to a proper assessment of cost versus risk. That is, what is it going to cost your company to defend a case to trial? Bearing in mind that the largest cost is usually the trial itself, the hearing itself, which depending on how many witnesses you've got, can cost a lot of money. And I mean, the other thing I find when acting for claimants is that, and you've used this myself as well, you'll go to preliminary hearing and you'll present the idea that you're going to bring an army of witnesses along. That can be tactical because it means that the trial is going to be very lengthy. The claimant will perhaps be more inclined to settle because they won't want to spend the costs of getting representation. It's a very long hearing. Bear in mind, though, that there are some claimants that just won't settle for love nor money, literally. Those for whom litigation is a matter of principle. And I would say to you, as an organisation as well, it's probably a fool's errand to litigate on principle. That's claim or defend. There's always a winner and always a loser. And I'd say, remember that play silly games, win silly prizes, because judges make mistakes. It can be advantageous to propose settlement at certain times of the year. Interestingly, pre-summer holidays, pre-Christmas, we've had success there where an individual might think a few £1,000s or a few £100 even will pay for the Christmas presents. So think tactically about when you're offering settlements as well.
That's a good but sneaky idea. Any other tactics you can recommend, such as cost warnings? When's it appropriate to threaten cost warnings? Well,
this comes hand in hand with the difficulties of unrepresented claimants. I think they can be unrealistic when untethered from reality, quite often, and without judicious legal guidance. You get all kinds of unmeritorious claims. But even when they are represented, some solicitors seemingly are not particularly adept at managing their clients' expectations. Financial pressure can be brought to bear on the unrepresented claimant. Offers in tandem with cost warnings can produce results, provided the warning is legitimate and the arguments you're making about the merits of the claimant's claim are reasonable and not unduly oppressive. I have had 3 recent successes with this. 2 of the claimants withdrew with no offers at all, and the third accepted a very low offer of low thousands, having put in a schedule of over 45,000. Bear in mind, though, that costs don't follow the event in the tribunal as they do in civil process. Cost recovery is the exception rather than the rule. It's quite a high bar you have to jump over to persuade an employment tribunal that the other side's conduct is so unreasonable as to warrant a costs award being made against them. But it can work.
Yeah, I've recently, this year as well, was instructed by an employer who'd made mass redundancies last year during COVID and have had a number of claims against them. And I think 4 out of 7 claims I've had withdrawn with a cost warning letter, but as you say, after filing a very robust defence, and one with a very low offer of, I think, £750 versus a claim for over a year's salary. So it really can work, but we always have to be mindful of being justified in giving that costs warning. So, you know, we always have to bear that in mind. Now, there's a sort of a different approach, and certainly I've seen the tribunals trying to push this a little bit more in all the preliminary hearings I've attended recently. And the judges have been asking us, will you consider judicial mediation? Especially given it seems that we're facing delays of about a year to get a hearing at the moment, whereas the judicial mediations, as I understand it, can come through in a few weeks. So tell us a bit more about judicial mediation.
I'll touch on it briefly. So it's offered largely in multi-day discrimination cases. It won't be offered in unfair dismissal usually, but where the tribunal sees actually we're going to be in trial for several days, it will invariably be offered. And what this involves is the judge effectively wearing the hat of the mediator. Parties trot along to tribunal, and provided both have outlined their position statements in advance and they're realistic and want to engage, then it can work. The judge will broach the subject, as I say, at the preliminary directions hearing, and if both parties are interested and appear to be realistic, then the case will be set down for mediation. And if it doesn't work, then it doesn't prejudice the later hearing, and the trial judge will not be privy to the outcome. So the judge that eventually hears the case won't have dealt with the mediation itself. I've had mixed results with it, but I think what it does do is focus the mind, because you've got this one day to try to resolve it. And particularly in cost-sensitive cases, it can work.
Yeah, I think it's definitely worth a try where possible. And Julie, once you're in a proper dispute, and probably ACAS have been contacted, there's always the option to settle things either via a settlement agreement or via a COT3. So I guess, can you just tell us what is a COT3 and what are the advantages of a COT3 agreement?
Sure. So a COT3 agreement is an agreement that is agreed via ACAS. So in order for it to be applicable, the employee would need to have started ACAS early conciliation and or have brought a claim. The purpose is to settle the claim at hand, but it can also be used to settle other claims too. Now, the main benefit of a COT3 is that it can be basically dealt with very quickly. Technically, it doesn't need to have an agreement signed. It can all be done verbally. So there will always be an actual physical document, but the agreement itself can all be signed off, finalised by telephone. So that means that it can be dealt with very swiftly. Also, it tends to be a much shorter document. The other key advantage of this is that the employee, the claimant, doesn't need to have legal advice in order for it to be binding, although normally the ACAS officer will go through it, especially with an unrepresented claimant or employee. Okay,
so given the sort of attractions of the COT3, speed, no lawyers involved, it can all be dealt with over the phone. Why would employers still want to use a settlement agreement instead? What are the advantages?
Well, with the settlement agreement, it can be used at any time, whether there's a claim or not. It also tends to be a much longer document and include more obligations and requirements on the employee. It tends to be the method that most employers will use to try to settle a dispute. But the thing is that with this, you do need to have legal advice. There are also some statutory requirements for a settlement agreement. One is that it has to be in writing. Secondly, as I've just mentioned, the employee will have to have had legal advice. The solicitor or legal advisor will need to go through the agreement with the employee explaining to them about all of the terms, in particular that it's likely to be in full and final settlement of more or less all and any claim that that employee may have. And the difficulty is that if those statutory requirements aren't met, then it would allow, it basically would mean that certain bits of it would be invalid. For example, the employee would still be allowed to bring statutory claims, and so could bring claims in the employment tribunal. But as I say, nonetheless, most employers will go down the route of a settlement agreement. The other thing with it is because the employee will be having legal advice, there is normally an expectation that some form of legal fee contribution will be made for the employee to get the advice.
Thanks. And yeah, I'd say on average, I mean, just for any employers who are wondering, for a solicitor to go through a settlement agreement with a client, on average, I would say it's about an hour to go through the agreement. If you've got a lengthier agreement, or they also need you to look at post-termination restrictions in their contract because the agreement refers back to their contract of employment, you're probably looking at an hour and a half, and that's just to go through the agreement properly with the employee. So that just gives you an idea of the sort of length of time it takes to properly explain all of this. And one thing that I wanted to do another poll is because I very often find, I think all of us have sort of said we have the same experience, that very often, you know, HR professionals will have a settlement agreement template that they either adapt or they'll have a lawyer draft it. And they don't necessarily, because there's not necessarily any reason that they would have done, have sort of considered in detail every single clause or what they do or why it's there. And this means that when they have pushback or you know, the employee wants to change certain things, they may not have 100% sort of knowledge on, okay, well, why do we have this? So I've just published a poll to say, you know, do you understand, you know, every clause of your settlement agreement template that you're using, the rationale behind it, the law behind it, etc. Because the offering that we have today it sort of may be helpful for anyone who hasn't actually ever been through it clause by clause and looked at it in that level of detail, you know, as you would need to if you were advising on it. And there's a fairly mix, so sort of about a third, if I end the poll there, about a third say yes, they understand every clause. Literally it's a 33% on all three. A third say no, and a third say not sure. And I think that's probably fairly reflective of you know, our experience. So the offer that we have to anyone that wants to take it up today is we're offering a 1.5 hour workshop. So basically everything you wanted to know but were afraid to ask about settlement agreements. And essentially what we would do with this, either sort of one-to-one or with a small team of HR, is to go through, take you through a typical agreement or your own agreement that you use. And we'll take you through clause by clause as though you were the employee being given it. And we'll explain the legal purpose of all the key clauses, and let you know what the sort of likely pushback will be and the considerations that you will have to think of if you're giving an agreement out like that. And this means if you issue an agreement in the future and you get pushback on certain clauses, it means that you're more likely to know, and it gives you an insight into what the employee experience is likely to be when they're on the other end of you offering them an agreement. So we're sort of offering this for £450 plus VAT for a session. And you know, we thought that would be a really useful thing to equip you with the full knowledge so that you can deal with them, you know, as and when they crop up in your business going forward. So moving on to alternatives to settlement. Meredith, what are the alternatives to settlement?
Oh, well, lots of things have just popped into my head, but I'm going to keep it on point. Mediation is what I was going to talk to you about. It's fair to say that if an employer has come to us to discuss the possibility of settlement, they might well rule that out. It's often overlooked, I think, mediation, but it's worth considering if the parties are open to the idea of attempting to iron out their differences. What do we mean by workplace mediation? Well, it's flexible, it's voluntary, and it's a confidential form of alternative dispute resolution used for resolving disputes. It brings the parties together in the hands of a neutral third party, and it concentrates on helping those involved to move from their entrenched positions to finding a resolution to a dispute. And they can help in a wide variety of circumstances, for example, as a result of allegations of discrimination, performance management issues, or following a dismissal even, a breakdown of trust or a clash of values. What are the advantages? Well, it can work. And even if settlement isn't reached on mediation, it is often reached soon afterwards. The parties have a better understanding of the issues and the differences and similarities between them, and on reflection may find a means of resolving their differences afterwards. It's very quick, as is judicial mediation. A mediation can be set up quickly, within days if necessary, and is usually completed within 1 day. And whilst settlement might be reached via a more traditional route, such as negotiation between solicitors or ACAS, this can be a protracted process. So mediation has that benefit also. It gets people talking, and we're all about talking at the moment in lockdown. People in conflict tend to take up rigid positions and avoid communicating with the party with whom they're in conflict. This encourages an accord between the individuals. And so it can maintain and repair relationships. It can also allow creative solutions, because individuals will often be looking for an apology. They might say, I want a letter from my employer to say how contrite they are. You can't get that in a tribunal. A tribunal won't order that. Whereas, you might agree to some form of carefully worded apology in the context of a workplace mediation. But it's not an easy way out. It is demanding, it can be emotional, it can be upsetting for the parties. Facing up and addressing issues and meeting with an opponent can be stressful. It doesn't stop litigation, because it might fail and litigation will follow. It isn't appropriate if you want to defend yourself, your organisation, in an employment tribunal setting because you want to send a message to employees that you follow correct procedures and will not settle unmeritorious claims. And that might happen if you've experienced a trend among employees who threaten and/or bring tribunal claims of a particular type. It shouldn't be used as an excuse or as a means to avoid or fail to deal with proper line management, where you think your line managers should take action. Employers should provide ongoing training to managers on how to deal with difficult situations, because if they do, you might never end up in this situation in the first place. Managers, in my experience, we've had employers where they've been performance concerns, but they haven't been tackled head on. And it's got to the point where there's no alternative but for the person to have to leave their employment. So it shouldn't be used as an alternative to tough performance management decisions, for example, in cases where the line manager needs to talk through performance issues. Where one party isn't committed, it's probably never going to work. Where you've got mental health concerns about an individual, you'll need to consider adapting the process and maybe allowing them to have a mentor with them. And it won't be appropriate in my experience in very serious sexual misconduct cases. I've got a case on for an employer at the minute where they brought an alleged harasser and alleged victim together in an attempt to reach an accord, and that has actually led the individual to bring a claim alleging that the mediation itself was an act of harassment. Bear in mind, it didn't advise the employer to hold that mediation. They came to me afterwards. It's not always appropriate, but it can work.
Thanks a lot, Meredith. And I think we've come to the end of everything we had to say. I thought we'd have more questions on this topic today because, it really is, the bread and butter of what happens day in, day out. It must take up most of HR professionals' time. But if there aren't any questions, I'll leave the chat open for a moment. If you do want to register your interest on actually sort of having that experience of going through the settlement agreement clause by clause, please do click on the offers box, click there and register your interest, and we'll sort of get in touch with you about that. If anyone has any questions, pop them in now, but if not, I'll say our next webinar is on unfair and constructive dismissal, and it's on the 13th of May, I believe. Please do make sure you've registered for that. And thank you for joining, and we will see you next time.
Many thanks.